Good evening. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. Before we get to the JRC, brief disclaimer. If you're unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, all pertinent links are right there in the description box. That way, should you like to do a deep dive on either subject, you should be definitely able to go ahead and do so. Trigger warning, this channel is marked not for kids for a reason. We do use profanity. And when we do speak about places like the Judge Rotenberg Educational Center, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children that watch the channel and they are 16 and younger, parental supervision very much advised. Now we're back to the smackdown of the government back from February 2025 when the JRC tried to appeal the new current proposed rule from the FDA to ban the GED device. So, let's get back to where we left off. And I promise you, some of these lines, these bars they're putting down, they're so good, they must be fattening. So, let's go ahead and continue where we left off. Plaintiffs offer various rationales to support their position that Exemption 5 is unavailable in this case. Summed up, plaintiffs argue that there is no reason to protect the process by which an agency arrives at an ultra-virus policy because the agency has no lawful reason to engage in the process or arrive at that policy. You have no reason to stop the GED! Have you read the rule? Because they clearly lay out what their reasoning is. Like, if ER documents, ER photos, and video surveillance footage doesn't convince you, I'm convinced that Jesus Christ could descend down from heaven right into your living room, and you still wouldn't believe it. I'm just putting it out there. Let me continue. Not so. Along the way to formulating a policy that is within its power to implement, an agency might legitimately identify and consider a host of alternatives, some within the agency's power to effectuate and some without. For example, an agency might consider the boundaries of its own jurisdiction, and the need for staff to speak candidly and confidentially is perhaps most important when discussion concerns unmapped and unexplored terrain at the border of agency authority. A backwards-looking test that nullifies Exemption 5's protection of the deliberative process, which may include conversations with attorneys, would discourage the kind of frank and appropriate policy-making discussions that the privileges were meant to protect and promote. Rather than lend support to the plaintiff's position, policy considerations thus demonstrate the need for agencies to retain the ability to invoke Exemption 5 protections even when reviewing a court subsequently concludes an agency rule was not statutorily authorized. In other words, there is no reason to do another review. Just because the original decision got overturned on a technicality doesn't mean that the reasoning behind the original decision, along with all the source material that came with it, it doesn't make their decision wrong. It was just stated they didn't have the authority to enact it due to that technicality. Now that the Congress has gone back and has given them that authority, the reasons for the ban remain the same. Because for obvious reasons. But you can't use it. You used it last time. It's an appeal, not a new case. Which means when you file an appeal, previous information discovered during the original deliberations remains relevant. You don't just, well, you can't use that now. Why? Is it too damning? Let's go ahead and continue here. Plaintiffs argue that defendant's application of Exemption 5 should be nullified because the deliberative process and attorney-client privileges are unavailable to an agency engaging in bad faith acts or when regulators engage in misconduct. So, according to the JRC, it is misconduct if you make a decision based on cold, hard evidence. Hear those crickets? Yeah, me too. Notably, the plaintiffs raised no accusation of bad faith at any stage of this case. So, throughout the deliberations, the JRC at no time made any accusation about bad faith on the FDA's side. At all. We read through the document. There was freaking nothing. Nothing. But now we want to use it to stop this. I'm sorry, Karen. It's not going to happen. Instead, as factual support for this argument, plaintiffs spill much ink over 10 pages in their brief, airing grievances against the FDA and citing instances they describe as misconduct in the rulemaking process. Plaintiffs appear to have imported arguments made in challenging the legality of the final rule to support their view here that the FDA engaged in bad faith in its rulemaking. Nothing in the record before this court, which does not have the benefit of administrative record in the rulemaking process, provides a basis to find that the exemptions to the deliberative process or attorney-client privileges for either government misconduct or crime fraud, respectively, should be applied here, even if those exceptions were available in evaluating the applicability of Exemption 5. In other words, at no point during the original deliberations did the JRC accuse the FDA of bad faith. They only did so when the new proposed bill came forward. The new final rule that all of us are currently working on until we're tearing our hair out. Thankfully, I have a lot of hair. I call my hair the beast for a reason. But, yeah, you made no accusations of bad faith. You're only using it now because it's pretty much all you got left. But what the government is telling you here is, but bad faith with the documentations. With the reason why the JRC calls it bad faith is because the FDA did not rule in their favor. Let me say that again for the idiots in the back. The reason why the JRC is screaming bad faith now is because they didn't get the decision that they wanted during the original deliberations. And they are pissed off that we had the gall, and that the FDA had the gall, to appeal the overturn that happened back in 2020. Yeah. But you didn't fold over and die and give up. We will never give up, JRC. None of us. Ever. Until your horror show is brought to an end and not a single other child will ever be at risk at being stuck in your hellhole ever again. Then we'll stop. Until then, sorry, but the government, it appears, at least in this document, is not buying your bullshit. And not only that, but they are starting to get the same headaches that all the rest of us who've been fine-tooth combing through evidence for years. It's alright, folks. Government folks, ibuprofen's your friend. Trust me. We're going to go ahead and close on that one, folks. We don't get very many views on this channel. The few we do tend to get removed from time to time. So if you folks would be so kind, please don't forget to hit the like button, hit subscribe. Don't forget to hit the comments, and make sure you're still set up to receive notifications. We are still continuing on with the Down the Rabbit Hole series, and we're also continuing with the Snake Oil Salesman series. We do not want you all missing anything. I do appreciate your time, and as always, we here at Spilling Tea do hope you have a good one. We'll see you all next time. Bye-bye, everyone.